So, well, folks, we are going to get started here in just one moment. I will let you know that these panelists have worked very hard on this project, and they've made a really dynamic presentation for you. I will say that you should be ready at your keyboard, because we have several polling questions that we would love your feedback with. You are on a webinar format, so we can't see you. That's probably good on some cases, but so that means you can wear whatever you want. You can be in your t-shirts or whatever, but we will be doing several polls throughout this presentation, and if you have a question, you can put it in the Q&A. We will try to take your questions as they come up, but we will most definitely answer as many as we can at the end of this webinar, and then we'll also give you the course number at the end of the webinar as well. So Louise, without further ado, I'm going to go ahead and let you introduce yourself and start the webinar.
Thank you. Good morning to all. Welcome to another Florida Bar presentation, which my co-presenter, whom you can see on the screen, David Lichter, and I hope will have some fun and some learning today. I'm Louise Zulli, and along with David, we are very pleased to present to you selected and thorny issues in Florida Bar arbitrations. We have a lot of material to cover today, as Chanel had mentioned, and so rather than go into our bios, David and I invite you, if you're interested, to take a look at them at your leisure. Otherwise, we're going to start with some required housekeeping measures. As Chanel may have mentioned, this is being recorded, and so once the video professionals finish their magic, make it all pretty, and say it's ready, it's going to be posted on the bar website. Number two, our PowerPoint will be available upon request to those who want it for their own personal information, but not for profit in any way. Number three, as Chanel mentioned, we're going to do the Q&A at the end, but Chanel has graciously agreed to monitor the Q&A in between time, and if she feels that there's a question's been posed that would be best addressed now, for whatever reason, she has graciously agreed to jump in and do so. And David and I both have told her, feel free to jump in anytime she feels she needs to do that during our presentation. And number four, we have to keep the Florida Bar CLE approvers happy. And to do that, we have to cover the objectives. So I begin with that. And Chanel, I'm pushing the down button, but I'm not getting anything to move.
Keep going.
Keep going.
Sometimes it was a little sticky for in our last presentation too. Maybe just click within the presentation. There we go.
That did it. Thank you very much. Number one, of course, we're going to be discussing the applicable law, the ethics rules, arbitrations rules, and statutes, covering Florida Bar arbitrations in general and some specific issues, because there are some unique features to a Florida Bar arbitration, which those of you and us who are arbitrators for other organizations may find a bit surprising. So it's important to keep available to you the Florida Bar Manual, which is posted on the bar website. It is going to be updated once the Florida Board of Governors does approve some recommended changes or new rules, which are there because of the hard work of the Florida Bar grievance arbitration committees and subcommittees, for which we are, I'm sure the bar is very thankful for that. But also the manual has suggested forms. Over the years, some suggestions on an award or an order of some sort have been requested. And so that's also incorporated into the manual. You can feel free to use it in its entirety, or their entirety. You can amend it as you want to, or you can just use it for reference purposes. But they do have some of the unique features required in Florida Bar Awards. So David and I encourage you to look at that, and look at it often when you get an arbitration assigned to you, just like you would look at the Florida Rules of Civil Procedure or the federal rules. You consult that to ensure that you are following it. Even if you've done it before, we suggest that you keep that manual available to you and handy. Number two, we're going to start from the beginning, and that's an overview of the Florida Bar's intake procedure for cases which are referred or not to those of us who are arbitrators with the Florida Bar program. Number three, we'll discuss some of the issues which bar arbitrators may face and suggested approaches to address. And at the beginning, you're going to possibly have an initial preliminary hearing, number four. And we're going to spend a lot of time on that. This is also known as a case management hearing, which is self-evident as to what it can do. To get you to number five, the final evidentiary hearing, otherwise known as the trial. And then number six, along the way, we'll give you some practical examples and our suggestions for best arbitrator practices. We have 6 objectives, and David and I want you to notice that we do not have as one of them on how to be an arbitrator. That's not what this course is about. We suggest that if you haven't taken an introductory course to be an arbitrator, that you do so, as both David and I have done, and are qualified arbitrators under the Florida Supreme Court. That will give you a different perspective as to this process. Even if you're a litigator sitting in the arbitrator chair, it can be entirely different with different considerations. So we wanted to make it clear that's not what we're doing today, if that was your expectation. So we begin at the beginning, which is the bar intake procedure before a case is assigned to an arbitrator. And as you already know, we have her here. We have Chanel Schuler here, who has graciously agreed to take us into the dive behind the scenes before you get that email that is assigned you either as a solo arbitrator or as a panel. And Chanel doesn't need any introduction, but I just want to remind everyone she is the director of ACAP, as you can see on the screen, which is the Attorney Consumer Assistance Program /intake, the key word, intake. And so she is our North Star. She's ever present, and we are so pleased that she's graciously agreed to begin the process for us. So Chanel, please.
Oh, thank you. Well, thank you for that nice introduction. So generally speaking, there's a couple of different ways that an arbitration can come about through our program. The first and probably most frequent way is through the grievance process. And so what we do here at ACAP and Intake is we've centralized all the intake of inquiries and complaints up here in our headquarters office. And we take a look at the information we receive and determine whether or not it should go on for further investigation, or possibly even down to a grievance committee, or whether we can't really prove a rule violation or the allegations don't amount to a rule violation. But then there's this outstanding fee dispute. You know, it's like my attorney didn't do this and that and the other thing and didn't keep me informed and didn't listen to what I was telling them and didn't, you know, contact my witnesses or whatever that case may be. And I think I need my, you know, some money back, or I don't want to pay the bill, or whatever that might look like in their particular situation. And so once we resolve the issue of whether or not there's been a rule violation, if we're going to close that file out, then we will offer a resolution for either mediation or a binding arbitration. And this program requires that the parties consent either in their fee agreement themselves or in a separate writing that we send to them with an invitation to participate in the program. The program is free of charge, which is a huge draw, because if someone already has an issue with their attorney over fees, they certainly are not looking to, do the whole throw good money after bad kind of thing. And so this program is definitely a benefit to not only the consumers, but also to our members, because it does help resolve those fee disputes without resorting to the civil court system. And there's many benefits, obviously, to that, to keeping those kinds of things out of court. Another way that I guess a sideline to that particular way is, again, if the parties at the outset of the representation agree in writing in their fee agreement and there is specific language that they have to put in that fee agreement under 4-1.5. It is a very specific language that needs to be put into a fee agreement if you are going to use that as the basis for participating. And it's actually a rule violation if you put an arbitration clause in there that does not follow that language. So it is very important for practitioners to follow the exact language of the rule. A bit of our cases that do go down to the branch office and that are investigated through the discipline process end up in diversions. And some of those diversions, that's just kind of like what you would think of in a criminal setting is, well, we see that there's the potential or, maybe even cross the line of a rule violation, but it doesn't really rise to the level of something that we would want to formally go through the grievance process any further. And so we divert the people, or the grievance committee will recommend diversion. And that happens about maybe 5% of the time where we do get a diversion to the arbitration program. And those are kind of special. This one and the next one with the Florida Supreme Court discipline cases, those are actually just requiring that the attorney participate and file for an arbitration. Obviously, we can't require a former client to participate, but in both the diversion by the grievance committee and also in a discipline case where the Florida Supreme Court orders the respondent attorney to arbitrate, they're required within a certain amount of days to file an application with our program, and then we send that application out to the other side seeking that other side's consent to participate in the program. So that's pretty much, how that goes if you want to advance. And so once we receive an application, let's kind of go through the process where we're just getting an application sent to us without a grievance. So we get an application, we open a file, we send a consent form to the other party. If they do not consent to the binding arbitration, then of course we close our file with a letter that explains that this was an optional program and we did not get the consent of the other side. If the other side does consent, then we have a fully assigned file. We will then determine whether or not a panel is required. Our rules provide that a panel is required for any amount in controversy over $15,000. The parties can actually request either a sole arbitrator when matters are over $15,000, or they can request a panel when matters are lower or $15,000 or less, but everyone has to agree on that change. So we reach out to our arbitrator or our panel members and determine their availability. By our provisions, the hearing is supposed to be set within 45 days of acceptance of the matter. So we do need to generally know that within that time period that our arbitrators can set the hearing. We don't lose jurisdiction. It's not a jurisdictional kind of time frame, but it is important that we move these cases along because we want the quick resolution of these matters for the benefit of all the parties. So with the arbitrators then conduct a preliminary conflicts check, and they will get back with us and determine whether or not they can accept the filing via their conflicts check and as well as their time frame. And then once we have all of that information, then the chair of the panel or that sole arbitrator then takes over everything and sets the hearing, coordinates the dates with the parties. There is no unilateral withdrawal after that whole, everyone has consented. So if both sides have consented to participate in the binding arbitration, then that is a contract. And everyone would have to agree then to not participate and to cancel the arbitration if one side wanted to withdraw. I think I covered everything on that slide.
Yes, thank you very much. With that finishes the introduction. Of course, Chanel will be available to answer any questions which might come up as well. And then we begin to move forward with that. And as Chanel had mentioned, we have a few polling questions, 16 as a matter of fact. So get your fingers ready to participate. This is anonymous, so nobody's going to know whether or not you got it wrong or you got it right. We're likening this to Dr. Kahneman's Think Fast, Think Slow, but this is going to be Think Fast because 15 of the 16 are either yes, no, or true, false. Only one is a multiple choice. So I don't know if you consider that your odds to be better depending on which position you are sitting in, but we're going to do the dive now. So a little bit of fun. Some of us are cat people, some of us are dog people, some of us are both people. We have a poll that says, when Sergio Botero has sent you the file, the email has arrived. There's a panel that's been appointed. The question, true, false, the bar randomly selects the chair of an arbitration panel, and everybody is just pushing those buttons, and we really appreciate that. So we've got people coming in. We're going to give it a little bit more. The bar randomly selects the chair of an arbitration panel, and it looks like we've got 100% in, and the answer is, let's get it moving forward. Hold on. False. Per the Fee Arbitration Rule, Roman numeral 4G, the panel selects the chair who's usually the most experienced. Now, the chair does a lot of work, and so that's why you want the chair, somebody with the most experience to do that. And the chair is always an attorney when there is a panel, just so you know. So the next poll, though, related to this is going to be handled by my co-presenter, and that is David Lichter. Thank you, David, for being so patient, and appreciate your taking it from here.
Thank you, Louise. Good morning, everybody. And the next poll question, we'll jump right into it. Poll number 2. An arbitrator must conduct an initial preliminary hearing in all Florida bar fee arbitrations, true or false. Get your fingers going, and we'll give you a few more seconds to vote before we go ahead and move to the answer. Okay, polls are closing, and the answer is very good. You can see it's 58. We have a majority that say that's false. And let's move to the next one. And in fact, that's correct. It is false. The rule does not require a preliminary hearing. You can proceed without one, but Louise and I both strongly recommend that you have that preliminary hearing. I mean, basically what you're doing at the preliminary hearing is setting the table for what's going to be happening. And frankly, since most of the participants on the claimant, if you will, side, the person complaining about the fee is usually, of course, the client, not the lawyer. And most of the time, the client is pro se. And so that is we'll be dealing with that issue along the way. But the fact is, it's your job to set the table both for the lawyer, who also may not have been through this proceeding before, as well as the client. So some of the things that you're going to address will be witness and exhibit exchange. There'll be a notice of final hearing. Louise mentioned a moment ago the bar manual. In there, it's almost a compendium. You're going to see all sorts of form orders, notices, articles, as well as the rules. So we strongly suggest you consult that. And it will give you that roadmap. And you're going to talk with the parties about how long they think the final hearing will be. It's not supposed to be more than 8 hours. They run anywhere from much shorter to right up to the edge. And one of the things that's very important, particularly as I mentioned a moment ago, when we're dealing with pro se, is to disclose our role. And you see a reference here on the slide to Florida Bar Rule of Professional Conduct 4-2.4, which I have in front of me. And I'm just going to read it, a section of it very quickly. It's called B is communication with unrepresented parties. And it says, a neutral must inform unrepresented parties that the lawyer is not, that means us, is not representing them. And when the lawyer reasonably knows the party may not understand that, you have to explain the difference between our role as a neutral and the lawyer who represents a client, including, as it goes on in the advisory committee note, says, including the inapplicability of the attorney-client evidentiary privilege. So the participants need to know that, no, we are not their lawyer. And can't represent them there. But again, it's part of setting the table. So we can go to the next slide. And in this order, and what you'll discuss with the parties at the preliminary hearing are deadlines, exchange, as I mentioned, for witness and exhibit lists, how people intend to appear. I've had both Zoom and I've had in person. It depends on where everybody is. These days with Zoom, of course, the cases are being assigned for people to handle around the states. They may not be in person, but in fact, if you're going to hold it in person, you're going to discuss that and who will be appearing by video, and then arrangements need to be made to make sure they have the proper technology. We won't spend much time on that, but something you need to cover with them. Of course, they'll be under oath to the extent they're going to be testifying. And what you'll find from the bar, if you haven't done this before, is when the claimant submits their grievance or complaint against the lawyer, by the time it gets to you, there'll be a fairly developed file, at least from the claimant or pro se plaintiff side. You may or may not have submissions from the lawyers, but you will again have deadlines to do that. So that will take us to the next slide. And right, are we there?
Yes.
Okay, okay, very good. Sorry, I was looking at my other screen here. Court reporters don't usually appear in my experience, but that doesn't prevent anyone from ordering them. Of course, we will tell the parties both at the hearing and the preliminary hearing that they're not to be recording it if it's over Zoom or taking screenshots or using their cell phones. Of course, we always have to be sensitive if an interpreter is going to be helpful. Then people should make arrangements for one. And then following the hearing, generally we get our decisions out within 10 days. That's what the rules require. There is a good cause exception, and you have to consult with the bar on that. But and remind everybody that this is a formal, it's a serious process, and they need to comply with the deadlines. Okay. I believe.
Fingers ready for the next poll.
All right, next poll, notice of evidentiary hearing. Now you've held your initial pre-hearing conference with the parties. You signed the order, you've sent it out. Now all you need to do is wait for the date of the final hearing, true or false. Let's get those fingers going and the poll. I'm not seeing the poll.
Do you have
I'm
the
not
poll?
either.
I don't see the poll.
Let's see. Hold on for me just a second. I needed to stop sharing that one. I apologize.
No
There we
problem.
go. Launch that bad boy.
Okay, there we go. Just a few questions. It's a short question, so please vote away. Are you done or not? And the votes are coming in.
We have some folks on their phones, so I think they're having a little difficulty
Understood.
doing those. I'm going to go ahead and share the results now.
Okay, and there's the results, and the majority says false, and in fact, the answer is, in fact, false. You don't have to, you must still send the notice of evidentiary hearing. That's a requirement, even if you hold the initial pre-hearing conference. And there's a form for that. It is in the manual. You can find it right there. In the old days, you couldn't send these things by email, but of course, now you can. And with that, I'm going to turn this over to Louise.
Thank you, David. We're going to go to poll number 4. We're a quarter of the way through. So now, I'm sorry. Now we have a bit of a fact pattern. Your respondent attorney wants to take the deposition of the pro se claimant under oath before the final hearing. Not surprisingly, the claimant objects. If one thing they know how to do, and that is to say objection. So the true false poll is the arbitrator has the discretion to allow that discovery. True or false? The arbitrator has the discretion to allow that discovery. And that, of course, is assuming that you've already heard some sort of argument and you are getting ready to rule. Either it's granted or it's going to be denied, and the objection is going to be sustained. It looks like the answers are in. The majority of you are saying true, that the arbitrator has that discretion to allow the discovery, and 25% say false. The answer is false. The arbitrator does not have that discretion under Rule Roman numeral 4D, which says that depositions are permitted only to perpetuate the testimony. The rule says all other pre-hearing discovery is prohibited. It doesn't say may, it doesn't say, well, perhaps, it says prohibited. Well, what does it mean to perpetuate testimony? And that would be if someone perhaps is ill, or someone is dying, and has a terminal illness of some sort, so they may not survive long enough to attend the hearing. Another type of circumstance could be that an essential witness whom the respondent attorney planned to call is not available during the final hearing date, which has already been set by the initial preliminary hearing. And that person may be on vacation, for example. Well, before you can make an informed decision, the attorney is going to have to comply with the rule and give you the reason and good causes that to order that the individual, the witness or the claimant, if the claimant is ill, needs to be deposed to perpetuate the testimony. That's not for the arbitrator to necessarily guide the attorney, or if it's pro se or a claimant who's asking to do that, that is the responsibility of the moving party. And it's important that you stick with the process in terms of not giving legal advice for the parties for a couple of reasons. One, you have to be true to the process. You are a neutral arbitrator. And number two, the claimant, if you're a sole arbitrator, even if there's a panel of 2 attorneys and one layperson by the rules, sometimes a pro se claimant may feel that the fix is in for the respondent attorney because either the sole arbitrator is an attorney or there are 2 attorneys on the panel. By the same token, the respondent attorney may feel that the fix is in, that we're all attorneys. And so, of course, the arbitrator is going to go along with what the attorney has requested without the need to have to comply with the rules. So it's really important that you do follow the rule, understand that, and make the make the movement follow the rules and meet the proof. Now, does that mean that the parties are not going to be disclosing to each other before the final hearing? Because there's a due process rule and reason for having a deadline to exchange witness lists, which will include factual summaries of witnesses, and the exhibit list so that people can prepare. You should not assume that merely because certain documents have been sent to the bar and then sent to you, that those are automatically exhibits. And that's one of the things you can explain at the initial preliminary hearing. Just because you sent it to the bar doesn't mean that it's an exhibit. And so it's very important that that is made clear to the parties. And the forms that we have do have those type of deadlines and the types of things and a direction actually to the pro se claimant or anybody who needs that as to how to list your witnesses, how to number them, and also your exhibits. Well, the rule says that, you can't do this except for perpetuating testimony, but there is chapter 682 under the Florida statutes, and it's generally the rule for and the guidance for arbitrators about having depositions. But the bar arbitration rule of 14-1.4 is going to be primary in what you're going to use. So with that, David, we're going to take you into poll number 5.
Okay, time for our next poll. When an arbitrator is concerned about a party's mental competence, the arbitrator should abate the proceedings. True or false? Let's see what people say. Clock is ticking, results are coming in, and very good. Let's end the poll. And the results are overwhelmingly people say true. The actual answer in our view is maybe. And that's because the arbitration rules, and it's actually Rule 8 entitled Death or Incompetence of a Party, really speaks to abating an arbitration proceeding when we receive either a suggestion of death, or in this case, for our discussion, a notice of adjudication of incompetency, unless there's a personal representative or guardian. So what happens then, and that's usually not going to be something that makes our way into our hands, but what happens when you have your preliminary hearing or you begin your final hearing and you really have concerns about one party or the other? And I think the reason we say maybe is what we think you should do is suspend, at least temporarily, the proceeding. Before you do that, of course, you really want to ask some questions, not intruding on, of course, protected health information of a party, the lawyer or the complainant, but rather just to see if you can ferret out, maybe, there was a medical maybe they're just completely and utterly not into it. They're distracted because there was some kind of tragedy in the family. I mean, people go off the rails, as you know, for reasons other than mental incompetence. So you want to ask some questions about how they're doing. They don't have to be completely forthcoming, but just to try to draw them out as to why maybe they're completely scattered. If they're really scattered and they really do not appear competent, then that's the time we think to suspend the proceedings and talk to your bar liaison, because no one wants to have an arbitration award that's entered that can be vacated because somebody is in fact incompetent to proceed. So that's why we assign this question a maybe. All right, we can proceed to the next one.
Thank you, David. Poll number 6, intervention, another fact pattern. And this is the multiple choice one. Your former pro se client, P, files a grievance against the criminal defense law firm associate for a refund of the retainer. The final evidentiary hearing is set for April 1. Everybody has agreed. April 1, you have your order out that sets it out. But on March 15th, the law firm for whom the associate works serves what's called a notice of intervention, meaning they want to be a party and part of the arbitration, even though the claimant has not filed a grievance against the law firm. So the question is multiple choice. Can the law firm participate on April 1? A, no, the law firm waited too long. B, yes, law firm claims an interest in arbitration and timely filed notice. C, no, the law firm is not a party. Or D, no, the Florida bar rules do not allow. So you have 3 no's and 1 yes. And we've got a variety of answers coming in from everyone, and they're still coming in. So we'll wait just a little bit longer. No, the law firm waited too long. B, yes, they claim an interest in the arbitration. They timely filed the notice. C, no, the law firm's not a party, hasn't been named by the claimant. Or D, no, the bar rules do not allow. And so with that, the answer is B, yes, the law firm can participate. It is permissive, but there are certain elements which the law firm will have to meet. Number one, the law firm claims an interest in the arbitration, and it is true, they hold the money. So even if the claimant got an award against the attorney, who's going to have the money? So it's in the interest of the claimant as well to have the party there who holds the money. Number two, the law firm did timely serve notice of intervention. The rule says it has to be, the notice has to be served at least 7 days before the final hearing. They served it March 15th. It's 15 days before April 1. And so the law firm met that criteria. And number three, the law firm has to agree to submit to the jurisdiction of the court, of the arbitrator, the Florida bar. They consent to that, and they're going to be bound by the final award. So having that in writing would be good, and certainly an order on the notice and request for intervention would also be required, so that you outline it, you say the things in terms of what had happened, in terms of the events, which rule allows you to do that, and the reasons why you are granting it. David, you ready for the next poll?
We do have a question, and
Sure.
it's, can the law firm request a continuance?
I can tell you from my perspective, unless there's a really good reason that they did not have notice, for some reason they lost it, and I would be looking at the respondent attorney who still works for this law firm and didn't inform his employer that he's submitting to the bar arbitration, my answer would be no, that they would not be allowed to continue it. This is at my discretion, and the condition is that they agree that we are moving forward on April 1. David may have a different perspective.
David does not. I think this rule is the common sense rule. It really isn't unique to law firms. It's really respect to everything that comes up of a nature of a continuance at a fee arbitration or any arbitration, which is, did the party have notice? Do they have a really good reason that it should be continued? Because you've got other parties there, presumably ready to go. So, whether you call it good cause or something else, I agree with Louise.
Any other questions, Chanel, on that?
Nope, we're good.
And thank you. That was a good question. Appreciate it. David,
Okay.
you're up for number 7.
Here we go. Next poll. Per the preliminary hearing order and or the notice of evidentiary hearing. In other words, once you send that order out, are you done? Do you need to conduct any other conflict of interest search, or can you now lay back and relax and just move forward with the rest of the hearing? True or false? All right, people are voting. It's an active participant group, which we like. Give you a few more seconds. And all right, very good. Let's share the results. As we can see, the majority say false, and the answer is, in fact, false. And this disclosure rule, of course, isn't unique for those of you who live in arbitration land and other organizations as well. It's a continuing obligation to disclose. And so, as the Florida statute puts it, would a reasonable person likely to be affected or think that you, the arbitrator, might be impartial or biased? And so when the rule is when in doubt, disclosed. And this is true, again, not just here, but everywhere. I mean, the worst comes to worst is you make a disclosure, okay, they'll go somewhere else and you'll volunteer another day as an arbitrator. But the fact is, there are very, very few reasons that arbitration awards these days are subject to challenge and overturning, and one of them, both in any form, really is failure to disclose. The other one has to do with process and due process, if you will. But so we have to take this obligation to disclose very seriously and disclose when we can. And I know Louise and I were talking, and Louise, you had some points about tools and what we use to engage in these type of disclosures.
Exactly. You and I both do this as arbitrators, and that is we keep track of the parties, attorneys, and expert witnesses who appear before us in any arbitration. We, as part of our obligation to do a conflict of interest, cannot rely upon our memories. The memory will fail you. It will happen. I know an arbitrator to whom it did happen. So we keep track in various software packages, Excel spreadsheets, Word formats, something somehow that puts in the names of all the parties. We keep track of what forum this may have been. We're both AAA and AHLA, American Health Law Association arbitrators, as well as others. We keep track of the attorneys and the law firms. Attorneys move as well. So it may be that the law firms has appeared before you. The particular attorney is now at another law firm. We also keep track of expert witnesses. It's almost impossible sometimes to keep track of all the witnesses who may appear in front of you. But one of the issues is an obligation as well on the participants, the attorneys, the parties, to, if they have noticed something that we may have overlooked or forgotten, or a witness has appeared in front of us, we ask that they notify the administrator, not the arbitrator, not us as the arbitrator. We don't want to know who may have a concern for whatever reason. They may not like my glasses today. It doesn't matter from our perspective. If you have an objection, then that goes to the case manager, to Sergio, or to the bar, who will handle that and let us know if we are still on the case. No reason is given, no reason is needed. As David had previously said, you move on to another arbitration. And David, if you would cover too, in terms of the lengths of time or the types of things that you will disclose no matter what. We discussed that as well.
Yes, I'll do that. And that'll also help with the question that I see that got asked, which is, the question implied you're going to conduct an independent investigation into conflicts. Why is that a conflict? So we're using the word conflict. 99 times out of 100, or whatever the percentage is, it's not really a conflict. The idea is, well, first, when we say independent investigation, is exactly what Louise just said. We're going to check, I keep a detailed Excel spreadsheet of all the things Louise mentioned. Neither of us keep all the witnesses who've testified before us. I think that would be impossible. It wouldn't be a conflict. But it's less about conflicts and disclosure, so that the person participating in the process is comfortable. Whether it's someone's appeared before me before as an arbitrator or mediator, or maybe you have a professional affiliation, maybe they're calling some witness. I just had it happen 2 weeks ago where an expert submitted a report, and that expert had testified in front of me. I think they were my personal CPA's firm, not the same person. And immediately, as soon as I found out, I disclosed it. No one had a problem with it. It's all about disclosure. And so it's not that there will be a conflict, but it's putting the information out there to give a person a chance to object and say, nope, I'm worried this arbitrator cannot be partial. And so they go to the bar, and the bar assigns someone else. So
I do have another question. You had mentioned Excel spreadsheets. Are there any other software packages that you all know of that, not that you're recommending them, but that you know of them that would do the same kind of conflicts check for you?
I know the bigger firms have them. I don't, because it's good enough, because I'm pretty much on my own right now. But I perhaps if someone's in the audience and they're part of a firm, unless Louise knows that they're running a software package, I don't have one to recommend.
I would say you can use any software that keeps track of your contacts. Any of the relational databases. I happen to use the old Time Matters which is now owned by LexisNexis, and I have a list of all of my contacts in there, and that software will do that. Even as simple as a Word document, you type in, you keep track of the Word document, you put everybody's names in there. I actually do that as well. I keep track of all the arbitrations, who the parties are, with which organization, and their law firms and expert witnesses. And I do a search in that as well. So it can be very simple. Any way that's going to do a search of a word that will let you know whether or not that individual, that party or law firm has appeared in front of you ahead of time. So that's what I would say, but just relying upon your memory is not going to work. It will embarrass you. It will, unfortunately, might lead someone to conclude, wrongly so, that you were trying to be partial in some way and adjudicate this particular claim, and not let them know. And that would never be your goal by any means, and it would be quite unfortunate. It would also have the person may also think, well, the bar arbitration process isn't so good. So from the very beginning, you do want to use something. David, you wanted to say
Yeah, I
something.
just want to say you don't want to go overboard, and that goes to the question we have, but meaning, look, you don't have to research the parties appearing before you. So if there's a lawyer on one side, obviously of a fee grievance, you don't need to investigate the lawyer to find out what organizations he or she,
Right.
or they are a member of, and then disclose. Rather, that's where your head's going to come into play. If you've seen someone, however, professionally or socially, even at these bar conventions or professional organizations, you simply say, from time to time, I run across so-and-so about once a year at a bar meeting. That's it. That's the disclosure. And so, again, it's not about going overboard, and we will not, as the questioner has asked, we're not going to disclose everyone who's appeared before us as a witness. We don't disclose, but I do disclose time period wise for arbitrations. I'll probably go back 10 years just to say so-and-so appeared before me in an arbitration, or a mediation, depending. Maybe since I have under my belt a lot more mediations than arbitrations, although I have a lot of both, I might limit it to 5 years. It just depends on the case, but certainly at least 5 years, maybe 10, just so it doesn't come up and cause a problem.
And if I could add to that, I always disclose a former employer, no matter how long it has been. And I've been a sole practitioner for many years. Again, the perception may be the fix is in, whether it's the pro se claimant or it is the respondent attorney. So I don't put a time limitation on that, but I also go back probably 5 to 10 years. And it depends as well. If I see that I've had this law firm appear in front of me in 4 prior arbitrations, to me, it doesn't matter how long it's been, they popped up. So I'm disclosing, and disclosure, by the way, is in writing to the case administrator, at least initially. As the case goes on, if there's a witness list, I do, if there's something, there's no additional disclosure, then I often will let the administrator know and let the parties know simultaneously so that they know that I'm checking on that as well.
I think it's also a timing issue, because if you're sitting there, I don't know, they forgot to call a witness, it wasn't on the list, and all of a sudden so I'm calling so-and-so, to be my next witness. So again, a lot of this testimony isn't often live witness testimony, but if you hear somebody right there on the spot, then you got to disclose it right away. And I know we've spent a lot of time on this, but I can't overemphasize the fact that there's very few ways to screw this process up. One is failure to disclose. So, and you'll see it, as Louise mentioned, as AAA arbitrators from time to time, we'll see people get bounced off a panel because one side or the other doesn't want them there, or a sole arbitrator. And that's fine. It's going to happen. I've been bounced a couple of times, not because I had an actual conflict, but somebody saw something in my disclosure that, maybe it was a client that got excited, or whatever. It doesn't matter. It's okay, especially in this forum where we're volunteers, and don't worry, you'll get another one. They will find you. Okay.
It's
So-
also appropriate, just real quickly, to remove yourself from having a certain law firm or whatever appear in front of you for whatever your reason is. And you can inform the case administrator if you get this type of person who comes up again, please don't even consider me. You don't have to disclose the reason. All they need to know, that will save them a step, is that you feel it's better for you not to even be considered to arbitrate that particular claim. So with that, I think, David,
Yes, let's move.
you're on to poll number 8.
All right. Poll number 8. At the initial preliminary hearing, the pro se claimant, former client, asked to submit written contentions and evidence instead of a live hearing. The respondent attorney agrees. Is that permitted? Yes or no? Okay, the numbers are coming in. All right, and
no, we see the
here we go.
no's are giving a
Overwhelmingly,
run.
everybody overwhelmingly already says yes, and the answer is yes. In fact, if the parties want to submit the decision to you on the papers, no problem. You're welcome to do it. The rules allow it, and there's no problem whatsoever proceeding in that manner. Okay. Louise.
Poll number 9, we're working our way through. Okay, you're ready. You've had the IPH, you've appeared, whether it's video, in person, you're where you need to be. And one party has not appeared. All right, you've waited politely a few minutes to see if they're going to call in or otherwise let you know, but they're not here. Yes or no? Can the arbitration proceed if a party fails to appear? And you're already voting, you're already in. The yeses are ahead. The no's are creeping up though. The no's are creeping up. We're still waiting to see. And it looks like it's in. The answer is yes. Under Rule Roman numeral 4B, the arbitration may proceed in the absence of a party who, and this is very key, after notice, fails to appear. Remember, we talked about, sending out the notice of evidentiary hearing. You need to do that even whether or not you have an initial preliminary hearing. This is one of the reasons. The bar may not get all excited if you don't conduct the initial preliminary hearing. They're going to get really excited if you don't send out the notice of evidentiary hearing, because every party, as part of due process, is entitled to know. But there are things that obviously you're going to want to do when somebody hasn't appeared. You want to make sure that there isn't a good reason. We have IT technology sometimes can fail. There can be, unfortunately, accidents. There can be a medical emergency, a family emergency of some sort. So you want to try to make contact. And I've had this happen only once. And when I still had an assistant, so I had her initially make the contact. But now, once that we figured out that the attorney just wasn't there, but was sitting in the attorney's office, then I got on the phone and in front of the pro se claimant conducted all of the communications about that. And why is that so important to do that? Not only the due process for the party who did appear, but if it's an attorney, you see Chanel nodding her head, she knows what I'm going to say, that's an ethics violation. You just said to the bar, please open a file on me, which you didn't do before. So you looked a gift horse in the mouth. They didn't open a file on you, but now they're going to have to do that. and it's going to have to also be part of the order, the process that you did. You attach the notice, you show that you've complied with the rule, that the attorney has gotten, if it is an attorney who has failed to appear, or even if not, has gotten due process. And then that's going to tell the bar they need to open up a file against the attorney.
So in the
Okay.
run up to the that hearing, you should make sure you don't only have the email of both parties, but their cell phones. Because if you need to reach them or find out something happened, or if Lily said maybe they had a medical emergency or a traffic accident or whatever, you want to be able to reach out to them to make sure it's not simply a failure to appear.
Thank you. Next poll. All right. Once the arbitration process proceeds, when the party fails to appear, can the arbitrator simply enter an award for the party who did appear? You say, okay, this is great. Volunteer, this is the least amount of time. All I have to do is enter this, send it to the bar, and we're off. Can the arbitrator simply enter an award for the party who failed to appear? And the poll is on. And we've got the no's, but the yeses are making a fast comeback here. We're still getting the answers coming in. Looks like all the answers are in, and the answer is no. Rule 4B, Roman numeral 4B says no award may be made without the submission of evidence to support the claim. So you have to move forward for the evidentiary hearing. There's a reason it's called an evidentiary hearing, otherwise known as a trial. You have to have evidence. You make the decision and you enter the award, which should include, again, the efforts you made to contact the non-appearing party, attach a copy of the notice, et cetera, et cetera. It's very important to document the facts. David, anything to add before we move on?
Nope, right on it. And I think that brings us to our next polling question. So you're ready to begin the final hearing. The pro se party has brought her son, saying he's there for moral support. The other side, the respondent attorney objects. Can the son attend the final hearing? Yes or no? Let's see those votes.
Yeah, looks like
Pretty
we've got a little more
split
ambivalence here.
It's like a horse race.
Yeah, it is.
What I like to see is the votes change, as we start commenting, they start moving around. Okay,
You
so
can't take your vote back either.
that's all right. So the answer, the yeses outweighed the no's, and the answer, in fact, is it's our discretion. And under Fee Arbitration Rule 4, of course, we have I'm just getting this off my screen. Okay, the parties have the right to attend all hearings, but we can exclude any other person who might be a witness or other persons once there's an objection. And I think this really does involve a number of considerations. First, you have to ask the other side why they're objecting. Are they just objecting to object without a reason? Is there a particular reason? For example, maybe the son is going to be a witness. And the attorney says, well, sometimes we call it a rule of sequestration in court. I don't want this person who is going to be a witness to be present. Of course, I suppose the person could testify if you decide to exclude them and then sit in the hearing after the testimony's in. You have to weigh that. But as the arbitrator, you also want to exercise control of the process. Those of you who do a lot of mediation, I think will appreciate the next comment, which is this. Sometimes the son isn't there, unless the son, of course, is there to be the person's lawyer, right? You have to ferret this out because we cannot allow people to engage in the unauthorized practice of law. So bringing your son or whoever, a friend, to represent you isn't going to work. The pro se person either has to represent themselves or show up with a lawyer. But if that's not the case, maybe it's simply a matter of anxiety. Person's very nervous, they've never done this before, and having that presence there simply calms them down. And those of you who mediate a lot, we certainly do this in mediation, is I'll go in and to speak to the other side, whether it's in person or over Zoom in a chat room, and say, look, person's here for moral support. It's going to make them feel better. They'll be less anxious. It'll go faster. you really have a problem with this. Now, you can't do that in an arbitration because that would be an ex parte contact, right? So you sort of have to do it when you're all together. But it's the same technique. And so I would, if it's an anxiety reducing factor, I consider it. And somebody just made a point of age may make a difference. Yes, older people sometimes get anxious, and very young people tend to also be anxious. So it's something to consider, and you should think about. Which takes us, I believe, Louise, unless do you have any further
I
comments?
do have a couple of comments, please. One is along the lines of you let them in. You also can change your mind if the son becomes disruptive in some way. You may want to just politely caution the son before agreeing to let him attend, and just remind him politely, of course, in setting the tone, that there are some rules by which he will have to agree, he's going to honor, and that you will, if he has difficulty or cannot abide by them, then you're going to ask him to leave the room. That's number one. Number two, you can also reassure if it's a pro se claimant, that this is an informal process with its own rules, something to address the anxiety. The pro se claimant will have time to present her case, even if you have to a little bit move it along. But again, just try to reassure her and address that. But the important point is you can change your mind, just like the mediator can, and say, well, I'd hope that you would be able to do this, but I see that this is not going to be working out, so I'm going to ask you to leave.
Yeah, I mean, I think that's a good point. I mean, the fact is we may be volunteers and we're here to help the parties, but ultimately we are responsible for controlling the process, making it fair, making sure it's fair and efficient, and doesn't go off the rails because someone is disruptive. So you should not be afraid to exercise your authority, as long as you're doing it in a fair manner to the parties.
With that, we're ready, David, for you to take us to the next poll.
Okay, an attorney's poll number 12, final hearing, expert testimony. An attorney's fee dispute commonly involves the arbitrator deciding what is a reasonable fee. Is expert fee testimony required? Yes or no? Okay.
Whoa, this is not being a horse race this time, although wait a
Very
minute.
lopsided. We'll see. Let's see what people say.
Yeah. Wait a minute.
Okay.
We're still voting. We have 56 to 78 participation. Okay, we ready, David?
Yes, I am. And the answer is, in fact, no. It's not required, but it may be permitted. And so when you have your initial pre-hearing conference, you should raise the issue with the parties to see if either one of them intends to bring an expert in case you decide a fee is appropriate. And there are deadlines, no less than 15 calendar days. They're supposed to disclose who those experts are. If somebody says they're interested in bringing an expert, then you can ask the other side if they want to bring an opposing expert, and you can give them a deadline, for example, a week later. I will tell you, I think that while in some fora, expert witness testimony is required, in this particular forum, I think Louise and I lean probably, not that we get a vote per se, but I would not encourage expert testimony for a couple of reasons. Number one, the pro se claimant's here because you're complaining about a fee, right? And so the last thing we want to try to do is sort of impose upon them the opportunity to incur fees finding some expert, especially if it's going to be a lawyer that they're going to have to pay hourly. I've had a number of fee arbitrations that no one yet has brought an expert. The attorneys usually think they're sometimes they are, but often they think they're the expert about why their fee is so reasonable. And so I actually have not had that arise because at the end of the day, I think that if you have, at least for the litigators in the room, the best way to ferret this out after hearing the evidence and testimony is usually what you're going to have. And I certainly always ask for, at least in hourly cases, and the attorney's billing records, right? And presumably at this point, there's not a privilege issue unless the attorney raises one, because it's the client that's complaining, right? So generally the privilege gets waived. And you go over these billing records and they can become, not only, they're very telling sometimes about how the lawyer did or did not spend their time. And so I think somebody had a question, Chanel.
Yeah. Yes, and they said if no expert, then the arbitrator has to use his or her subjective opinion. And is that then an appearance of bias?
Well, it's a good question, but I think the point you're making is you tell the parties, look, you have a right to call an expert, but I'm experienced. My job here is to decide what a reasonable fee is, and I'm going to listen to the testimony. I'm going to listen to the evidence, and it's my job as the arbitrator to make a decision about what is a reasonable fee if I decide that a fee is due and owing. I think that's how you set the table for the parties. And then if they're worried about bias, then they can find an expert. But like I said, I think that in most cases, you're going to find that that's not going to be done. Either the lawyer doesn't want to spend the money or doesn't think that we need one, and the client doesn't want to spend the money hiring an expert. So I think that's part of our job, is to show the parties why we're not biased. And we do that by modeling, we do by the things we say, and the fact that we're going to consider all the testimony and evidence and make a decision. But at the end of the day, that's our job. We've got to decide whether A, a fee is due, and B, what's a reasonable fee. Looking at, and the billing records is the best way to do it. Now, of course, we should always have, and if there's a written fee agreement, there better be one. The bar rules require written fee agreements in writing.
There isn't always.
There isn't always, but you should look at those. Now, in contingency cases, it's a little trickier, and we don't have to get into that in any detail today. Most of the fee disputes I've seen are hourly, because the clients are charging hourly, and the contingency fee, obviously, they'd have to win, and then the lawyer would have to presumably, take a percentage in excess of the bar rules. And so I don't think we need to get into that today, but something you should keep in mind as well.
We have had requests for arbitration prior to a final resolution of a contingency matter, and generally here, as an administrative matter, we will let them know that that's not ripe yet. So we would actually have to have, an award on the backside of the contingency matter before we could even make any sort of assignment.
I would add to that sometimes the issue is whether the flat fee, which criminal defense attorneys often charge, the issue may be, is it refundable or is it non-refundable? And there is a bar ethics rule on how to notify, the requirement to notify the client that it is non-refundable. And so that's where whether or not there's a written contract signed by the client and the attorney or law firm is also important to address. Now, I also saw there's a question about board certified and non-board certified attorneys. And I'm not sure if the question is asking, would our answer be different if we're dealing with a board certified attorney versus not? And the rule does not distinguish that, unless I'm misremembering, Chanel, but the rule does not distinguish whether or not a fee expert witness is required for a board certified attorney or versus not. And the rule does not address that, to my recollection.
Our rule does not address that in the fee arbitration rules, but I think that under 4-1.5, which is our main rule about fees in general, that would probably address and be one of the just factors that would go into reasonableness.
Yeah. And before we move to the next slide, just wanted to note that due to the hard work of the committee and the subcommittees, there is a pending cost addition to Roman numeral 4E, so that not only attorney's fees, but also costs are recoverable. Costs are not in there. So we're hoping that the Board of Governors will approve that amendment to the rule so that fees and costs are going to be recoverable. Did I cover that, Chanel?
Yes.
Okay. Anything else, David, before we move on to poll number 13?
I did see there's a question pending. If a panel has been selected and the final evidentiary hearing has not been scheduled for months, long past 45 days, can the parties request a new panel be assigned? Also, can the panel just arbitrarily pick a date without clearing with the parties' counsel, given that the Fee Arbitration Procedural Rules require conferral? So I suppose, I mean, hopefully, I know the way Louise and I practice, I would have a problem with the premise because when you get these assignments, you are not letting months go by. And in fact, the bar will come after you. If you do not get that hearing scheduled within 45 days, they're checking in with you. So it's not likely to happen. I will let Chanel handle the answer about requesting a new panel, but I can say that no, we won't arbitrarily pick a date because the whole point is this is a process by consent, certainly going into it. And so it's not for the arbitrators to willy-nilly, assign a date without some input from the parties. But Chanel, do you have anything further to say about that?
Yeah, I think it has a lot to depend on the circumstances involved. If the arbitrators, especially if there's a panel of 3 and they're all agreeing on, 10 dates out there, and then the parties themselves are not in agreement, or they're being obstreperous in actually setting the hearings. I mean, sometimes people who even, consent to these, or especially if they're forced to go through, because of a fee agreement, or they believe that they're forced. I mean, they agreed to it on, on the front end of a fee agreement. But sometimes they can be obstreperous to actually setting the hearing. So it really sort of, depends upon those circumstances. But procedural rules do say that that the arbitrator or the panel chair confers with the parties to set a date. If there is some issue with the date, sometimes, setting that date and then having the parties say something like, well, I'm not available then, you have to reschedule, or at least forcing them to, file something with the arbitrator then says, okay, provide me with the dates, then you are available. And it's not, appropriate for you to say, I'm not available for the next 6 months, something like that. So, I think it would only happen in a very rare case where an arbitrator or a panel chair would be in that situation. But if it does happen, it's usually a way to just, provide for the date to actually be agreed upon then. And, once that date is agreed upon, especially if it's been that hard to get, you got to be bleeding or dying to get a continuance. Okay. Like, just make sure you show up and be there. So
you're in the OR. You're in the OR. But
yes.
The good news is that Zoom works on phones. So
that's right.
Probably before the the prevalent use of Zoom, that people weren't physically able to show up or be available. They're on the yacht in the middle of the Caribbean. Guess what? The Bluetooth and the satellite are going to find you out there. The question also presumes that there may not have been an initial preliminary hearing in which everybody already agreed this is going to be the final hearing date. Mm-hmm. So if you recall on the slide, and David reinforced, orders and deadlines will be enforced. So if someone is now asking you to, or they're not responding, the initial preliminary hearing is the good time to say. And if you try to tell me or the panel later on that for some reason you're not going to appear, or you become non-responsive, then my approach, or the panel's approach, is we're going to give you an opportunity. We're going to send out notice. We're going to give you sufficient notice, and we are moving forward. The rules, which we covered, allow us to move forward as long as you've been given proper notice. So you want to say that politely and incorporate them and make sure that they do understand that. But that's a way to move forward on that. Anything else, David?
We're good.
Okay.
Okay.
All right, poll number 13, we're getting there. We
We're good.
promise sometime before closure of the final hearing, whether it is before it has begun or subsequently, parties announce they have settled. Yes or no? Must the arbitrator enter an award? Sometime before the closure of the final hearing, the parties announce they have settled. Must the arbitrator enter an award? The no's so far have it by a long shot. So wait, here come the yeses. They're picking up. All right. We're going to move on to the answer. The answer is no. The arbitrator is not required to enter an award. With the settlement, actually, jurisdiction to some respect has been lost. The parties have already agreed that what they're going to do. And the easy, simple way to approach it, which Dave and I recommend, is you enter an order of dismissal. The bar needs an order because it shows that the attorney appeared. Remember, if the attorney doesn't appear, it's an ethics violation. So the bar needs the order of dismissal. If the parties want you to attach the settlement agreement, which they drafted, neither David nor I recommend that you get into the business of drafting anything for the parties. Remember, you're the arbitrator. You make decisions as a neutral. They've told you, they settled, fine, I'm done, order of dismissal, parties have settled, you send it off to the bar. Can you enter an award if for some odd reason the attorney wants an award to be entered? Well, you can under Fee Arbitration Rules, Roman numeral 6. And it's not your job to tell the attorney what the rule says, because the rule says, and the Fee Arbitration Rule 14-6C says, if there's an award, the attorney has to pay within 30 days if there is a payment obligation of the 30 days of the award becoming final. But even if requested, again, we do not recommend you draft a settlement, but you can attach any signed settlement agreement to an order of dismissal. Yes, ma'am.
Louise, I'm sorry. I do want to jump in here because this is really an important thing because, when you get into those arbitrations and, there is something where, the parties may, again, come to you and say, okay, we've figured this out, but, here you go. We want you to enter this. And when it says something like the attorney gets to pay over time, this is the problem with that. Because the arbitrator, you're like, oh, wow, the parties have agreed to a settlement and that's great. And they want me to sign off on it now. And then that violates that rule. We then come back because if the Florida bar is going to monitor that payment, it has to be done within 30 days. If that settlement agreement, then now all of a sudden, you have entered an award about, then says that it goes past that 30 days. Maybe it's over time, over a year or something like that, these payments happen. What happens with us is like, we have to go back to the arbitrator and say, we can't do that. The only way we can do that is if the former client then would agree that the Florida bar does not monitor this situation. That means if that attorney fails to abide by that agreement, that award, then they would have to go and handle this through the court system, because we're not going to monitor it past the 30 days or monitor 6 months or 12 months of payments. Our rule says 30 days. That's what we monitor. If the attorney does not pay within that 30 days, then they go delinquent. So now I guess, the reverse of that is there's no such requirement on the part of a former client that has to pay the attorney. We have jurisdiction over attorneys here, and what we do here with attorneys with reference to this fee arbitration program is different than how, it might work out with a former client.
Thanks, Chanel.
Thank you. And now we're coming to the thorny issues. David?
Okay, so this is more of a general discussion of things that will come up. And some of it I think is common sense, but there are going to be times, for example, that you're going to have a difficult party or a witness. With respect to that, I think you put on your common sense mediating hat, it depends how they're difficult. There's a difference between someone who is anxious and asking lots of questions and venting versus someone who is disruptive. We already talked about the disruptive person. You're going to have to exercise your authority and explain politely but firmly that you have a process to run if they have a particular question, but it's not the time to be yelling or disrupting the process. On the other hand, again, this is part of what we talked about earlier. If you have someone that's anxious and they're all over the place, once again, you want to bring them in line gently but firmly. If they need to get something off their chest, that's okay if it's not done in an overly aggressive way, but use your common sense to set the right tone. I think that with an unprepared party or witness, and this does happen from time to time, once again, you have to find out why they're unprepared, just like the person who may have, God forbid, had a car accident or some tragedy in the family. You know, somebody shows up unprepared. If for the similar reasons, you know, they've been in the hospital the last whatever week or 2 weeks and they haven't been able to focus or prepare, okay, use your common sense. In my mind, that would be a legitimate reason to continue the hearing. On the other hand, once again, as Louise said, there's a reason we give notice. And sometimes we give notice more than once in the preliminary hearing order and the notice of final hearing. And if it's some throwing the lawyer on the sword here, if the lawyer's like doesn't really care about this, isn't paying attention, sort of forgot it's on his calendar, and then you call up and it's like, oh, I'm not ready, and the other side's ready to go, and there's no legitimate excuse, then I think you're within your rights to go ahead. Again, listen to why they're unprepared and don't have an excuse. Now, of course, again, you cannot be the pro se person's lawyer, but you can assist with process, like, ask questions. Do you have any exhibits to offer? Do you have anything to say? So, that much you can do. We already talked about Rule 24. And handling a difficult arbitrator fairly quickly, because I see we're beginning to run out of time. Louise, do you want to speak to that briefly?
Yes, thank you, David. This would be in the circumstance in which you have a panel and maybe the wing is having a problem somehow, some way with another arbitrator or the chair. Well, as an experienced chair, you typically set up an executive session so that everybody can get to know everybody. And one of the things you can ask the chair is, how would you like to handle, or how do you handle X, Y, and Z? Or if I need a break, how would you like me to handle that? Because the chair really acts as a mediator among the all three arbitrators. And most of your chairs are going to be receptive to a private conversation if you want to have that, if you haven't been able to resolve whatever the issue is with another arbitrator. That's what the chair is there to do. So we encourage you to speak up, do your best to be as neutral, put your mediator's hat in asking the question. I haven't had an experience, and I don't think David has either, where we were unable to work things out among the arbitrators, because having a good functioning panel is going to be important to the chair. David, anything?
Nothing further. I think it's time for our next poll question.
Okay, and that means I'm up, and that is this is going to be number 13 and 14 together, so it's going to be quick. Mediator to arbitrator, that role, or arbitrator, mediator to arbitrator. First one is the med-arb, as it's known. Sorry, let me go back. Parties ask the arbitrator to mediate before the final hearing, and if not settled, to arbitrate the claim. Should you accept? Yes or no? While you're answering that, the other one is after the final hearing, but before the final award, the parties ask the arbitrator to mediate. If no settlement, enter the award. Should you accept? So, should you accept the role of being mediator to arbitrator, or you're the arbitrator, they've asked you to mediate, if you don't get it, they don't get it settled, to go ahead and arbitrate. Is that something you should accept to do? We still have some answers coming in, but I think that we are ready. The answer is we do not recommend either situation. There is what's called an opinion by MEAC, Mediators Ethics Advisory Committee. And that's from 2015-003. It is a controversial opinion. And in essence, what for the Med-Arb opinion is that, well, you can do mediator to arbitrator, but there are lots of pitfalls, and there are so many things you have to make sure of when you're doing that. One of these is the parties must have a, quote, complete understanding of how a mediator's role will change. And two, they must waive conflict of interest and the confidentiality of mediation. But the MEAC opinion says, but be cautious. Well, if you look at the two-page dissent, the two-page dissent is where David and I sit in terms of the camp. We don't think it can be done. We don't think it's going to be effective. You keep on one hat, decide which hat you want to have. That's fair to everyone. Mediation is an entirely different process from arbitration. You are making the decision as the arbitrator, and so we do not recommend this. David, you have any additions?
No, I think you're exactly correct. It's if you're arbitrating, you certainly want to hear people will tell you things in mediation you shouldn't hear as a neutral, and vice versa. Even if you're arbitrating first and then you mediate, and then you mediate, you're going to hear things. You may put you don't want to put your finger on the scale. So you want to stay neutral. We think it pollutes the pure process that we like to abide by. So other than that, why don't we hit the last polling question?
The last polling question, we thank you for hanging in with us. David.
Yes. Okay. Are Florida Bar fee arbitrations proceeding confidential? Yes or no? Let's see what folks have to say about this. Things are moving around. Okay. All righty. And the majority say yes, and we think this is the big surprise. The answer is in fact, no. And you need to be careful here because it's chapter 14-7.1 of the rules. All the records of our proceedings here in fee arbitration are public records provided on request, except for our mental impressions, what we might call work product, either among a panel or yourself. This is important because those of you who arbitrate in other fora like AAA or AHLA as arbitrators, you're bound to keep it confidential. The parties generally keep it confidential without getting too complicated about this. Sometimes there are additional confidentiality agreements that are entered into in the process, but certainly there aren't going to be public records requests going to the AAA or AHLA or you as a private arbitrator. So this is important because when you send emails to parties or when you write things down or your award or whatever it may be, at least hypothetically, it could be out there for public view. So be careful. This is so I think there's enough said on that topic. We've got, I don't know, Chanel, maybe a minute or two remaining for any other questions. I think I see one in the queue.
We have a couple of questions.
We do. We're at Q&A now.
Yes,
Right,
records retention for fee arbitrations at the Florida Bar are 2 years. Don't send us the records. We don't want them either. But yeah, they're 2 years. And let's see, there was a question going back to the previous slide. Can you continue an arbitration so the parties can mediate with a mediator?
I think so. I think we have the discretion. We always encourage parties to settle. So my view would be is, sure. Obviously what you want to do though is if somebody announces they wish to mediate, then you want to say to them, okay, if both parties agree, it's a consensual process, then let's pick a date by which you should mediate and report back to me, the arbitrator. So, you keep their feet to the fire, you keep the bar informed and get the bar's permission, since you are supposed to have a hearing within a certain amount of days and the decision. But I suspect the bar, unless Chanel tells me otherwise, will agree as long as the parties attempt to resolve it among themselves.
And that would be an issue you could address at the initial preliminary hearing. You can put it right in there, a deadline by which to mediate if they want to do formal mediation, whatever it is, because you have to keep your eye on the ball for that final hearing to move forward. And that's one of the ways that you get to do that. There's another question that Susan actually had asked about how do the rules of evidence apply during the informal arbitration hearing?
That's not me.
Well, that's not
That's
you.
not me.
Oh, I'm sorry. That's not you.
Someone is answering it under Susan Austin. It's
Oh, okay. Somebody's answering.
or somebody's saying.
Arbitration, on any arbitration, whether it's the bar or another arbitration, the rules of evidence are loosely applied, and that's going to be the discretion of the arbitrator. And what you will learn when you take that elementary introductory arbitrator course is you say, and you do, and we will give it the weight. If you overrule an objection, we will give it the weight that it deserves. There are some things which you feel should not come in, are totally irrelevant. You're not going to consider it, and so you're going to sustain it. But that's typically the way it's approached. Dave, you have something to
Yeah, I
add?
think the short answer is they don't really apply. And Louise's answer is the best. It's the favorite arbitrator answer. That unless it's so far afield and so off base and has nothing to do with anything, I'll let it in and give it the weight it deserves. And I think there's one more very interesting question, Chanel. Can parties stipulate the confidentiality?
Well, so long as we don't have the records, they're not subject to public records, right? The Florida bar is an arm of the Supreme Court. We are not under the rule chapter 119 of the Florida statutes like the legislature is. We're under the rules of judicial administration. So if we have the records, we have to give the records, and only certain things are marked as exempt. So if we have them, we have to give them up. So I guess that in that particular scenario, then just be wary of what the arbitrator has and to keep and what is submitted to the bar. Anything that's in a bar complaint, generally, if this would start as a bar complaint and then be referred to an arbitration, that record is actually going to be a public record and subject to distribution once it is reviewed by our general counsel's office for any exemptions.
And so with that, this is what the attorneys have been waiting for.
There you go.
The CLE number, which you must post yourself. The bar doesn't do it for you. Course number 7520, attorney CLE, course number 7520. You must post it yourself. And so with that, on behalf of David, we greatly appreciate your enthusiasm. We hope you've had as much fun as we have in doing the presentation. You all have been terrific in terms of your very thoughtful, pointed questions to facilitate the learning. And last but not least, David and I are very thankful for all that Chanel has done to support us through this process. She's ever present. She's always answering our questions and with a smile. So thank you again, Chanel, for your contribution and for assisting us today.
100%. And thank all of you for your continued service to the bar. It's very important that we do these things and help people navigate problems with their lawyers and hopefully get them resolved in an efficient, fair manner. And again, thank you, Chanel.
Thank you. Thank you both. This was a tremendous presentation. We really appreciate it. Thank you all for attending.
Thank you.
Bye-bye.
Bye-bye.